read the word, please, on the card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Please have a seat.
Thank you.
Yes, Mr. Carr.
May it please you, sir. Could you start by giving us your full name, please?
Nicholas Hunt.
And if we could have HOM 30202. That's your very short witness statement for the inquiry, which you signed on page 2 on the 8th of October.
That's correct, yes.
The reason that that is such a short statement is because in it you adopt paragraphs 192 to 293 and Annex B of Ms Elsmore's witness statement, which we have at HOM 4078, because you can speak more directly to that than she can.
That's correct, yes.
And should we take it then that, although those paragraphs are in her statement, we can treat them as your words for the purpose of this afternoon?
Yes, you can.
Just then to deal with your experience and role and why it is that you are able to address the topics we're covering today. You're a Deputy Director and the Head of Firearms and Weapons Policy Unit in the Home Office's Public Safety Group.
That's correct, yes.
You have held that role for the past 4 years, from October 2021.
I was Head of Firearms Policy from October 2021, and I became responsible for knives and offensive weapons from January 2024.
Thank you. Earlier posts include being the lead on knife crime within the Home Office between 2014 and 2019.
That's correct, yes.
I think between December 2019 and October 2021, you were the Secretary to the Daniel Morgan Independent Panel.
That's correct, yes.
Thank you. Could we have HOM 4078 and page 57 up, please? And could I just ask about the Home Office's general role in respect of knives and offensive weapons? You set out there at paragraph 194, the Home Office is the central government department with responsibility for legislation and policies to tackle knife crime and offensive weapons.
That's correct, yes.
And that includes the sale, purchase and possession of knives and other such weapons.
It does, yes.
It involves, both as a matter of legislation but also of policy, working with other government and non-governmental agencies, law enforcement, charities, local government, those sorts of
It does a range of players, yes.
Presumably also with other elements of government, the Ministry of Justice, Department for Education.
A wide range of departments, yes.
Youth Justice Board?
Indeed, yes.
And you flag there that other bodies like individual police forces, the National Police Chiefs Council, the College of Policing and the CPS have separate roles and responsibilities in this area, particularly operational decisions and
Yes.
police and prosecution guidance.
Yes, they do, yes.
Could we go to page 80, please? And just to situate ourselves with the scale of this issue. The year ending March 2025, police recorded just over 53,000 instances of knife-enabled crime.
Yes, that's correct.
And that included 204 knife-enabled homicides. And bearing in mind the period year ending March 2025, that of course included the dreadful murders of Elsie, BB and Alice.
Yes.
That 53,000 instances of knife-enabled crime also included nearly 23,000 cases of assault with injury or with intent to cause serious harm.
Yes.
And if we could go to page 101, please. In terms of trends across time, this is a table of police-recorded knife-enabled crime, excluding the numbers recorded by Greater Manchester Police due to issues over their statistics. If we look at the penultimate row, can see that the total numbers of police-recorded knife-enabled offences dropped from 2010 to 14, then rose steadily and significantly from 2014 to March 2020.
Yes.
There's then a fall in 2020 to 2022, which I suspect you will agree primarily attributable to the pandemic.
To the pandemic, yes.
And it then begins rising again before a small drop from 2023 to 2024 to year 2024 to 2025.
That's correct, yes.
What we have at page 103, and I can deal with these very briefly, another way of looking at the same problem, because you can perhaps show all sorts of things with statistics, but if you approach it from two angles, we might get a better overall impression.
Yes.
This is the figures reported by the NHS for admission to hospital for injuries caused by assault with a sharp object.
Yes.
Just over 3,500 such admissions in the year ending March 2025.
That's correct, yes.
And a similar, not perhaps exactly the same, but a similar pattern going back in these figures to April 2012 of a rise, a fall, a rise, a fall for the pandemic,
yes.
And then something of a slight rise and a recent slight fall.
That's correct, yes.
The other thing that this information gives us is a sense of the extent to which the harm and destruction that these offences cause is focused on young people.
Yes.
Because what we can see from here is that between a third and 40% of such admissions are those in the age group 0 to 24.
Yes.
And then the remainder above 24.
Yes.
And I think reflecting the severity of this problem, from 2022 there has been a serious violence duty imposed on a number of bodies, including police, local authorities, health agencies, youth offending teams, fire and rescue, probation.
To work together, yes.
To work together.
Yes, yeah.
So the serious violence duty is not something that we should see as akin to the prevent duty, which has a focus on individuals susceptible to radicalisation.
No, it's a different concept now.
It's more of a coordination function,
Yes.
a duty to cooperate,
Yeah.
for those agencies to work together and to produce a strategy.
That's correct. It's to bring them together, to work together, to build a plan together for the overall area, rather than focusing on individuals. Yeah.
I'll come later on to some of the initiatives that might form part of those strategies. But before I do that, could we just get the legal framework around the purchase and possession of knives and offensive weapons, both in respect of adults and children? Could we have page 58 of this document, please? And paragraph 200, please. So can I start with specifically bladed and pointed articles rather than offensive weapons more generally? First of all, there's no distinction between what is permitted and in respect of possession of bladed or pointed articles for those over 18 and those under 18.
There isn't, no.
It is, as you say there, an offence to have a bladed or pointed article in a public place without good reason or lawful authority.
That's correct, yes.
And there is then a further similar offence dealing with having a bladed or pointed article on educational premises.
That's correct, yes.
That essentially deals with the issue that a school might not be a public place
Yes.
for the first offence.
Yes.
And you then also have section 139AA, an offence of threatening someone with a bladed or pointed article or an offensive weapon in a public place or on school premises.
Yes.
So it's a step up, not just having it, but threatening
But
someone
threatening
with it.
as well, yes.
And each of these offences applies to any article with a blade or point, except for a folding pocket knife with a cutting edge of less than 3 inches.
That's right, yes.
Save in respect of some specific kinds of weapons, and I'll come to those, there is no current offence of possessing knives or other bladed or pointed items in a private place.
No, there isn't, no.
In terms of some of those specific examples, there is the Restriction of Offensive Weapons Act 1959. Originally, that prohibited the sale of what are known as flick knives and gravity knives.
Yes.
And then since 2019 and the Offensive Weapons Act, that also prohibits their possession.
It does, yes.
And then there are also weapons whose possession in private is prohibited under Section 141 of the 1988 Criminal Justice Act. Thank you. We see that in 205.
That's correct, yes. Yes.
And just to give us a flavour of the sorts of weapons that covers, they're defined in a statutory instrument under the Act, curved swords, zombie knives, belt buckle knives.
That's right.
Foot claws, push daggers, butterfly knives, cyclone knives. There's a whole range.
There's a long list. I think it's about 22 in total, yeah.
And that schedule to the order that sets these all out has been regularly amended in response to changing trends.
It has been, yes.
Would you agree with this, that the legislative history in this area, prohibiting particular items even in private because of their particular dangerousness or nastiness, has been something of a cat and mouse game where a gap in the existing legislation is identified because of a particular type of weapon emerging, further legislation being passed to address it, and then the kind of weapons that are used evolving to get round that prohibition?
I can see why that might be thought with this particular piece of legislation. It's introduced to allow Parliament to decide that particular weapons should be added to the list. So I can see why it might be portrayed in that way, but it is an effective power in terms of removing weapons from circulation once is added to the particular list. But I understand that it might be portrayed as some kind of cat and mouse game. I understand the point you're making there. And so one of the things that we're trying to do through the Crime and Policing Bill currently going before Parliament is introduce a new offence around possession with intent to unlawful violence, which covers both in public and private.
And we'll come to that offence, Mr. Hunt.
Yeah.
Could we have ILT 4042 and page 2, just to get a sense of the way in which the current regime prohibits an item? This is part of that statutory instrument. And if we could look towards the bottom of the page, and I think it goes across the top of page 3, paragraph SA, which deals with a zombie-style knife or zombie-style machete. It's quite a recent addition.
It is, yes.
Schedule, bladed article with a plain cutting edge, a sharp pointed end, Roman 3, a blade over 8 inches in length. It tells us how to measure the blade. And then one or more of the features specified in paragraph 1A, and which is not a weapon that falls under paragraph 1S. Paragraph 1A, page 5, please. And if 1A could be enlarged. And just reminding ourselves that there only needs to be one of those features, but it could be a serrated cutting edge, more than one hole in the blade, spikes, more than 2 sharp points in the blade. You end up with quite technical definitions of quite specific kinds of weapon that have to fall into that description in order to be prohibited.
That's correct. That's the approach that's been taken, and we consult on that as well to make sure that we can try and identify what we're trying to prohibit as exactly as possible before it can fall the legal definition which falls into the order.
Yes, because there's obviously a risk of unintended consequences if you inadvertently define a knife which is prohibited by a description which would also include, for example, a bread knife.
Well, that's what we're trying to avoid by bringing in other types of knives which don't need to be part of the order. That's correct.
Thank you. Away from knives and bladed items, and so in terms of offensive weapons generally, again, no distinction between under and over 18s in terms of what it is lawful to possess in public or private.
There's no difference, no.
Key statute here, Prevention of Crime Act 1953, defines an offensive weapon, any article made or adapted to cause injury or carried with the intention of such use.
That's correct.
And so depending on the facts, that could cover a bow and arrow, a sledgehammer, or indeed a hockey stick.
It could do. It very much depends on the facts of the case.
And it makes it an offence to have an offensive weapon in a public place without reasonable excuse, but places no controls on possession in a private place, such as the home.
Yeah, that's correct.
And then there is also a bespoke regime in respect of crossbows under the Crossbows Act 1987,
Yes.
and that is focused on the sale and purchase and the possession of crossbows by those under 18.
That's correct. That is only for crossbows, yes.
Yes. A conventional bow and arrow, if I can use that term to distinguish them from crossbows, the sort that one might see in the Olympics, it is quite capable of causing serious and even lethal injury if misused, isn't it?
It can be, yes.
But save where that would fall within the offensive weapons category because of intent, there are no controls on conventional bows and arrows.
There are no specific controls on bows and arrows, no.
Why are crossbows and conventional bows treated differently?
I think crossbows are a link to, they're involved in crime. Over the last 10 or 12 years, I think they've been linked to about 14 or 15 separate homicides. They are relatively easy to use compared to conventional crossbows, to bows and arrows. Today they increasingly look and resemble firearms in many ways that they fire off. Whereas bows and arrows are very rarely been used in crime, that they're relatively cumbersome and require a high degree of skill to fire as well compared to crossbows, which are comparatively easy to use.
Yes, I think there may have been a case in July this year where there was a conventional bow and arrow, a compound bow used in an attempted murder, a domestic.
But those are
domestic
relatively
murder.
rare compared to crossbows.
We'll come on to purchase and sale of these various items, but are there any other provisions you would like to draw attention to in respect of possession of weapons?
We've covered the Prevention of Crime Act 1953, that's the general provision, but otherwise, no, thank you.
Thank you. What there isn't then in the current law, as regards possession of bladed items, is any prohibition on the simple possession of a machete,
There isn't, no.
even for those under 18.
No.
And we know that in this case, although AR ultimately used a kitchen knife on 29th of July 2024, he made considerable efforts to obtain machetes.
Yeah.
Could we look at HOM 30134 and page 45, please? Just while this comes up, this is the College of Policing problem-solving guide for knife crime. You're familiar with that?
I am, yes.
And what the College of Policing has said there, informed by the 4 A's framework, attractiveness, availability, affordability, and accessibility, we found that the attractiveness of certain knives, such as machetes, appears to outweigh the difficulties of sourcing them, availability and accessibility, or the risks of being arrested in possession of them, affordability. And from the graphic below, we can see that machetes were the largest or joint largest weapon used in knife-enabled murders in London for the period that they analysed. And I think you were here at the inquiry for ACC Winstanley's evidence in respect of Lancashire.
I did hear that, yes. Yes.
Where he said, I think rarely a day goes by when we look at our morning summaries and there hasn't been an incident the day before where somebody has either been attacked or threatened with a machete.
Yes.
It's fair, isn't it, to describe machetes as a popular weapon for those who are intent on threatening or carrying out unlawful violence?
They've got a lot of appeal, yes.
We've heard evidence from sellers of machetes. Mr. Wheeler of Knife Warehouse estimated that in 2023 his company sold around 100 a year. Mr. Bullock of Springfield estimated his company sold around 1,000 a year.
Yeah.
That's, of course, only 2 sellers. Machetes aren't items that typically require regular replacement.
I wouldn't have thought so, no.
Appreciating that this is no doubt a far from scientific approach, do those kind of figures seem at first blush consistent with the demand for machetes being solely for purposes such as land clearance, agricultural use, perhaps camping?
I couldn't say we don't have that kind of data, but whether that's a large number compared to the demand for them, I just couldn't say.
I mean, there is a key question, isn't there, whether the demand for machetes for legitimate purposes is, in fact, hugely outweighed by the supply of them, which would suggest that they might well be being predominantly purchased for unlawful purposes because of their popularity for that very purpose.
We don't have data from retailers about the uses, but we understand, as you no doubt you went through the evidence with the retailers, that that there are a number of people who say there are legitimate uses for machete knives, whether in forestry or agriculture. In terms of data and use of machetes in crime, the most authoritative figure we have is in the homicide index. And for 2024, I think out of around about 260 homicides involving knives, I think 18 were involving machetes, which is obviously 18 too many, but it gives you a feel that that's around 7% of the overall total. But in terms of other crimes, we haven't got data on the use of machetes and other types of knife offences.
Has there been consideration given, I appreciate what you say about the data, but given what the College of Policing appear to have identified in this report, given the anecdotal evidence that we have from Mr. Winstanley, has there been any consideration given to whether a prohibition on the possession of machetes, either at all or for under 18s, might be a good idea?
In 2023, there was serious thought given to a prohibition on machete knives, which led to a consultation in April of that year talking about prohibiting certain types of machetes, and essentially was trying to test the ground about where the line could be drawn in terms of which machetes could be banned and which would remain available for legitimate use. The conclusion of that consultation was that to bring forward a ban for zombie-style machetes as one with no legitimate use whatsoever.
Yeah, and we've seen the effect of that conclusion. Can I just test this a little, particularly as regards those under 18? Do you think there's an inconsistency between the treatment of crossbows and the treatment of machetes, given that the possession of one of them by an under 18-year-old, possession of a crossbow by an under 18, is an offence in and of itself, whereas the possession of a machete might or might not be, but is dependent on factors such as intent?
I understand how you're drawing out the difference between possession in private of a crossbow and possession in private of a machete. In public, they'll be treated the same, but in private, I can see why you're making that distinction.
They'd be treated the same in public because a machete would be treated as an offensive weapon because
yes.
you would expect a police officer on the ground, if they find a 15-year-old in possession of a machete, to be treated as having it for intent.
If you have, exactly, you have no good reason for carrying that particular knife.
Yeah, if they say they're off to the allotment, the police officer might find themselves in a little difficulty.
Yes.
Without wanting to labour the point, unlawful violence, particularly involving young people with machetes, on any view is far more common than unlawful violence involving young people involving crossbows.
And I started to talk about earlier, we were bringing forward a new proposed offence in the crime and policing bill where make it illegal to possess in private.
I promise you we will come to that, Mr. Hunt. Can I turn to purchase and sale of the various kinds of weapons? We've just been dealing with crossbows, dealing with them quickly. It is an offence under the Crossbows Act to sell a crossbow, or indeed to hire one, to somebody under the age of 18, whether in person or remotely.
That's correct, yes.
And I think there are current proposals in the Crime and Policing Bill to bring the controls and restrictions on remote sales of crossbows to under 18s, or remote sales of crossbows generally, rather, in line with the age verification requirements that apply to bladed articles.
That's correct, yes.
Not an offence, though, to sell a conventional bow and arrows to somebody under 18, or to do so remotely, and we've discussed reasons for the difference in approach. Could we have HOM 4078, page 62, please? While that's coming up, it's an offence to sell various pointed or bladed articles, including knives, to somebody under the age of 18.
It is, yes.
And there is a defence to that offence if the seller proves they took all reasonable precautions and exercised all due diligence to avoid the commission of the offence.
Yes.
And then as regards remote sellers, if we could go to page 63, please, the next page. And paragraph 221, there's further specific conditions that have to be met to establish the all reasonable care and due diligence.
That the defence can be made out, yes.
And you've set those out there. We have looked at them in evidence previously. I'm not going to go through them in detail. Could we go to page 65, in paragraph 226, because there are some other related offences created in the Offensive Weapons Act. There was an offence committed by the seller when a knife is delivered into the hands of somebody under 18 at a residential address.
Yes.
And then in section 39, there is an offence on the part of the deliverer.
Yes.
Where that occurs.
Yes.
And in both cases, the offence is committed when the parcel is received by somebody under 18.
Yeah, it is, yes.
And there is, in both cases, an all reasonable precautions and due diligence defence.
Yes, there is.
We've obviously heard evidence from a number of remote sellers of knives. No doubt the responsible ones will seek to do their best to comply, and you've highlighted in the statement substantial guidance for sellers about what appropriate systems are to meet the due diligence defence. Would you agree, though, and I understand you attended the evidence of the weapon sellers,
yes.
Would you agree that there appears to have been a variety of approaches taken to those requirements?
I agree. There's a range of responses.
And in places, there was something of an incurious or even perhaps irresponsible approach that led to AR on multiple occasions being able to circumvent age-verified purchase requirements by using identification that didn't belong to him.
Yes.
Or, in the case of Amazon, for age verification for purchase for the knife of his attack, for the knife used in the attack, he provided false details, i.e. the details for his father, which were checked with Experian, and that was regarded as sufficient.
Yes, I heard that, yes.
And there was no requirement that the details submitted for age verification of the purchase matched the details of the purchaser under that system. Mr. Bamfrey for Amazon, which of course is one of the largest online retailers, accepted that that age verification process meant almost any child that could use a computer would be able to pass it.
Yes, I heard that, yes.
What was your reaction to hearing that evidence, please?
It was very concerning evidence to hear that a supplier like Amazon was prepared to say that and had that view of its system. It's pleasing to see that they've since made changes to their system, which appears to be much more in line with for example, the guidance set out in the statutory guidance issued by the Home Office in terms of the checks that should be made, but it was concerning to hear.
That is age-verified purchase. In respect of age-verified delivery, it appears that the purchases that AR made appear to have led on more than one occasion to AR receiving directly weapons despite being under 18. Again,
That's very concerning. The legislation requires that the package be handed over to somebody 18 and over, and that the packaging is clearly labelled 18 plus a bladed article, so that the person receiving it knows what's contained in the package.
Some of this is obviously down to individual suppliers and individual couriers and how they take steps to comply with their existing obligations. I think you would accept that the regime that the Offensive Weapons Act 2019 created for age-verified purchase and delivery of weapons remotely was not watertight.
I would agree on that, looking back on retrospect in terms of the detail about the age verification controls. I agree.
If we could have HOM 30125 on page 2, please. In fact, if we could just have page 1 just so that we can situate ourselves. This is the announcement in February this year of the measures which we're going to come to in the Crime and Policing Bill.
Yes.
If we could go to page 2 and the sorry, start at page 3. Yes, top paragraph. The description by the Home Office of the regime in place prior to the changes that the Crime and Policing Bill is intended to enact was described as having lethal loopholes in the sale of knives online, which are allowing dangerous weapons to end up in the wrong hands.
Certainly the age verification controls weren't as strong as we're now proposing to do by introducing the checks, yes.
Yeah. I mean, this is the Home Office's own language
Yes,
here in this press
know.
release, isn't it?
Yes.
It's the Home Office's own description of its own legislation.
It is. We recognise that there were failures in terms of the age verification controls at the time.
And the Crime and Policing Bill seeks to address that. I'm not going to go through clause by clause, you'll be grateful to hear. But first, it imposes stricter requirements on age-verified purchases. So they would have to involve provision of both an official form of identification, passport, driving licence and so on, and also I think a current photograph such as a selfie-type photograph.
It does, yes.
So that confirms that the ID belongs to the purchaser.
The person, yes.
And then secondly, it requires that the person who makes the purchase is also the person who receives the delivery.
It does, yes.
And so what we heard about checks on the electoral roll or with credit agencies being used as part of the age verification process, under the Crime and Policing Bill's changes, that would no longer be an acceptable form of age verification.
No, they would have to show either driving licence or passport.
It could perhaps be used in conjunction, but it would not by itself be enough.
It wouldn't, no.
And likewise, the provision of the selfie-type photograph alongside an official form of ID is intended to mitigate against the use of false identification.
It is, yes.
Both of those steps, dealing with false identification and ensuring that the purchaser is the same as the person receiving the delivery, might be thought to be really quite obvious gaps in the system that the 2019 Offensive Weapons Act brought in. Is that fair?
If I can just provide a little bit of context to what was happening in 2019, 2018, insofar as the sales provisions on sales of knives were brought up to date to reflect the increasing move to remote sales to online sales of knives, and the legislation was updated to reflect that. The original proposal, consulted on in November 2017, was actually to ban all online sales of knives completely. Following the consultation on that exercise, provisions were brought forward to ban the delivery of bladed products to residential addresses, blade products being knives with a particularly cutting edge, which might cause serious injury. During the passage of the bill through the Houses of Parliament, amendments were brought forward, which were agreed with the government, to allow blade products to be delivered to a residential address, subject to the defences being met, which were introduced into the bill at that point in time. We didn't go so far as to prescribe the actual nature of the age verification checks to be undertaken by retailers, because we should rather prescribe that. The argument was that retailers themselves should be able to establish the age verification checks consistent with their business model. We also didn't want to put something onto the face of the bill which might be rapidly dated at the time that the bill was going through. So that's why what now seem to be gaps or loopholes in the law, that's why we're now trying to amend the law to kind of fill the gaps which might have been perceived to be the case when the bill was introduced in 2022 and the measures introduced in April 2022.
All right, thank you. Those gaps, therefore, have now been identified and addressed through the Crime and Policing Bill, and that is likely for responsible sellers to provide, one would hope, significant assistance in ensuring that both purchases and deliveries are properly verified and to the right person.
Yes, we hope so.
That still leaves an issue over the irresponsible sellers, doesn't it? Either companies focused on the sale of knives who simply pay little or no regard to their legal obligations, or informal sellers, for example, through social media.
As the inquiry are probably aware, we commissioned a review of online sales of knives led by a senior police officer, Commander Stephen Clayman, the National Police Chief lead on knife crime. And he brought forward a number of different recommendations, one of which was the establishment of a dedicated police team to help enforce the law in this area, particularly the measures which the government was then bringing forward around the sales of knives, so to kind of bolster and make sure there's a much more robust law enforcement approach. Secondly, if we can just move on to it as well, again, subject to Parliament agreeing, the Crime Police Bill increases the sentences for sales of knives. And what's really important about that is it gives the police greater investigatory powers, because they'll no longer be summary-only offences, so they have greater ability to investigate crime.
In terms of enforcement, and we'll talk a little more about the Clayman review shortly, in terms of enforcement, when looking at how these offences are committed, the recipient of a knife who is under 18 has no incentive to report that they have been given a knife, been delivered a knife, been able to purchase a knife in breach of the law, do they?
No, they don't, no.
Because the offence is only committed when the knife is actually handed to somebody under 18, both the person carrying out the delivery and indeed the seller may well not realise that an offence has potentially been committed.
Possibly not, no.
Neither of them, if they did realise that an offence had been committed, would particularly have an incentive to self-report and hold their hands up to it, would they?
No.
And particularly when dealing with an irresponsible seller, they simply aren't going to care that they're in breach of the law in any event.
That might be the case.
So on the fundamental structure of the legislation, these are offences which are extremely difficult even to detect, let alone to investigate or prosecute.
Possibly so, but that's not unique. But I understand the point you're making by the delivery chain now you've just sketched out, yes.
The inquiry's heard evidence that Adrio Limited, trading as Hunting and Knives, sent somewhere in excess of 2,500 packages via a complex supply chain 99.9% of which contained knives and should have been age-verified deliveries, but none of which were. And we can't say how many of those were actually delivered to someone under 18 and would therefore have involved the commission of an offence. Is that something that concerns you?
It was very concerning when I heard the evidence being given about that particular delivery chain. Section 42 of the Offensive Weapons Act 2019 requires the person making arrangements with the overseas seller to make arrangements to make sure that they're taking due diligence and reasonable precautions to make sure that those knives that they're receiving from the overseas seller are delivered into hand to somebody over the age of 18. So the legislation is there, but I understand the point you're making. It's very concerning.
Has there been consideration, it sounds as though there may have been, has there been consideration given to imposing much more significant restrictions on the remote sale of knives and other offensive weapons, either at all or to people under 18? It sounded as though that was consulted on some years ago.
It was consulted on some years ago. The idea was consulted on. There wasn't that much support for the idea, particularly in Parliament as well. And so measures brought forward which significantly tightened the law with respect to remote sales, but arguably, as we now look back, didn't go far enough. But the measures that we're now bringing forward in the Crown Police Bill will help fill some of that.
Yeah.
It will fill that particular gap.
They tighten the regime for purchase and delivery, but it is still an activity, the remote purchase of knives, that can be engaged in lawfully.
It is, but we, in addition to Crown Police Bill, a way to help regulate the sector as well, we're also giving very serious consideration to licensing or registration of knives, which again is an idea put forward by Commander Claimant in his report, and the government's committed to consult on that later this year.
I was going to come to that. The licensing of sellers of knives has some precedent in this field because firearms can only be sold by a registered firearms dealer, can't they?
That's correct, yes.
And so that means that there is, first of all, a requirement that the dealer is a fit and proper person.
Yep.
You can have various individuals who are prohibited persons,
Yep.
for example, because of prior convictions. And equally, it means that there is scope for licensing conditions. You can have a register, has to be kept, of what sales have been made. You can have reporting obligations.
Absolutely, yes.
So you say that is... I think you said that the government was intending to consult on that later this year.
That's indeed.
Would you be able to keep the inquiry up to date on the progress of that consultation?
Absolutely, yes.
There's other possible alternatives as well, short of an outright ban on remote sale of knives. One would be, for example, to limit or prohibit the remote sale of pointed knives. Would that be an option?
That could be an option. I'm not sure how acceptable that would be to the wider general public in terms of the range of knives which might be covered by that description, but it could be an option.
Another might be perhaps a narrower class of knives, machetes. They could be in a category where they can be purchased for legitimate use by somebody going to a bricks and mortar store. You can't buy them online.
That could well be something. It's not something we're actually considering, but again, it's an area which we keep under review all the time. One of the things I say, coming back to the offence, is one of the reasons that the offence we're proposing the Crown Policing Bill to introduce to deal with a situation where a farmer in Northumbria might have a legitimate use for machete clearing, farmer well away from a power source, whereas somebody living in a flat in an inner city area might have less reason to have a machete. Is why we're keen to test.
I'm certainly not suggesting, Mr. Hunt, that any of these are going to be a complete solution to what is obviously a complex and multifaceted problem. I'm simply putting them up for consideration and for your response. But these are options, aren't they, that fall some way short of a complete ban on the remote sale of knives, but that would impose additional challenges on those seeking to obtain knives for unlawful purposes.
They would do, for example, provided that bricks and mortar shops apply the right checks when selling machetes, but yes, they would.
It's much easier to deal with bricks and mortar shops. You know where they are, and you can send a police officer or a trading standards official, not you, but one can send a police officer or trading standards official round to check. It's much harder to deal with somebody selling a knife on Facebook.
Indeed, it's an interesting suggestion.
There are also offences as regards the sale of knives under the Knives Act 1997, which relate to unlawful marketing of knives. You cover those in paragraph 218. Ms Ellsmore covers those at 218 of the statement. Summarising, it's an offence to market a knife in a way which indicates or suggests that it is suitable for combat or is otherwise likely to stimulate or encourage violent behaviour involving the use of the knife as a weapon.
Yes.
Again, we've heard something about some of the advertising online of knives in the inquiry. Knives with product or brand names such as Predator, Cold Steel and Walking Dead. An all-black knife, an all-black machete, where the colour was described as being useful to avoid scaring the fish. Knives described as having a pointed tip for stabbing. And one described as useful as a stabbing weapon. I'm not going to go so far as to ask for your view on whether or not those or any of them would amount to an offence. Does it suggest to you a sector where there is proper and responsible regard for how knives are advertised and for the obligations under the Knives Act?
Certainly those examples are very concerning. Yes, it does suggest that that there's an issue there in terms of what's being advertised. Again, going back to the review of online sales of knives, but it was quite a comprehensive review done just 12 months ago or less, and it did touch upon this, about the use of the Knives Act 1997, and it was described as challenging to law enforcement. And so one of the ways that we've been looking to deal with that is focusing on the weapons themselves rather than the unlawful marketing, which is why, for example, the ban on zombie-style machetes, the ban on ninja swords, rather than focus on the unlawful marketing. But I do take the point you're saying, and one of the things that we want to try and do with the new police team being put together is that it'll build up a particular expertise in a broader area of sales and knives issues, for example, the unlawful marketing as well.
And I think there is also there are also proposals in the Crime and Policing Bill that would enable content takedown for material that contravenes UK law on the marketing of knives.
That they would do, and it's designed to pick up either unlawful marketing weapons, contrary to the Knives Act 1997, or indeed someone shown possession of an offensive weapon.
And I think that also comes with potentially significant financial penalties for both, for the technology platforms that host such content, but also senior officer liability in some circumstances.
That's great. There'll be a civil penalty notice for both the platform and a designated director as well.
And that would apply, as I understand it, to social media sites as well as to traditional websites and the more obvious platforms for sales, such as Amazon?
It would apply to search engines like Google, apply to social media platforms, apply to online marketplaces.
And in terms of enforcement of that, you've told us about the police team that is being set up and funded. Would that largely be for them to develop how that is to be enforced?
It would be. We've developed a process of content removal notices which that the unit would be able to use against particular platforms of concern to get the material that the account closed down within 48 hours or so. That's notice being issued.
I want to deal with one further aspect of the crime and policing bill now. There's an element of it that I understand is known as Ronan's Law, which is named after Ronan Kanda, victim of a knife murder in 2022, killed by 2 individuals, one of whom had stockpiled a small arsenal of edged weapons, including machetes.
Yes.
There is intended to be a new reporting requirement where somebody buys weapons in bulk, and again summarising and omitting some exceptions such as blocks of kitchen knives. A retailer would have to report any purchase of more than 6 knives, not only in a single transaction, but also to the same person or to the same address within a relatively short period of time, 30 days.
That's correct, yes.
It's not a prohibition on selling weapons in bulk. It's a requirement to report when you have sold weapons in bulk.
It's a requirement to report that to the police, to the new police team we're setting up, so they can then use that information, compare it to intelligence got elsewhere, to understand why that purchase might be going ahead.
Can you help with why it's a after-purchase reporting requirement that is intended to be brought in, rather than just prohibit selling 6 knives at a time to somebody?
Well, there may well be legitimate reasons why that person wants more than 6 knives at a time, but if the police are being sent a report by the retailer that purchase has gone through, it may be, as I say, reveals other criminality going on, whether they're involved in the grey market as a seller, or, as has been the case in recent past, going to county lines gangs to equip the people in that particular gang. So there will often be other signs of criminality linked to that sale as well, but not all the time.
Is there a risk that it's a relatively straightforward requirement to circumvent? If one wants to accumulate a stockpile of knives, even in quite a short space of time, one can simply purchase from different sellers, or perhaps make purchases from the same seller just over 30 days apart.
That of course, is possible, but there is that check in the system that there's a duty to report that to the police that purchase is going ahead. We're trying to build again on the recommendations in Commander Clayman's report around suspicious transactions involving knives. We're focusing on online sales of knives. And we think that building on the evidence that Commander Clayman acquired as part of his review, that it goes to some way to combating somebody looking to buy knives in that way, whether it's a grey market seller to sell them on, or otherwise be the case.
You mentioned Commander Clayman's review. I think Commander Clayman recommended not only reporting requirements for bulk purchase of knives, but also, as you alluded to, suspicious purchase of knives. And I think that was, in the announcement we looked at briefly a few moments ago, HOM 30125, where it was said that would form part of Ronan's Law. Am I right that the requirement to report suspicious transactions separately from bulk transactions isn't in the bill?
We regard, I think we would consider the bulk purchase be a suspicious purchase, buying that number of knives either in 30 days or in one go. In terms of actually just having an individual suspicion threshold, I think it would be very hard to define in a way that would make meaningful sense to retailers. So therefore we're focusing at the moment on the bulk purchases.
We've heard in this case that AR made a number of inquiries of weapon sellers to see what their age verification requirements or indeed how they would deliver the weapons. Would it be in an obvious package or not? And that some sellers do already make a practice of reporting suspicious attempts to buy particularly age-verified weapons to the police. Yeah. Would it not be sound policy to have a reporting requirement for that on sellers?
Again, it's an interesting suggestion. We looked at that as part of the work preparing for the Crime Police Bill based on the recommendation made by Commander Clayman. I think as you say before, individual retailers, if they consider something to be suspicious, will already go to the police about this. Whereas if you're trying to define that in the bill, we thought we'd prefer, at the moment, to leave it at a bulk purchase.
Are these sorts of reporting requirements, either the bulk purchase ones that are being introduced or possible ones about suspicion, are they the sort of thing that might be assisted by a licensing or a registration scheme? Because if sellers have to be licensed or registered, then they know that failure to comply with the requirements of that is potentially going to risk losing them their ability to operate.
We think when subject to the consultation and legislation in due course, licensing regime will make that much easier, because there'll be requirements placed on the licensed seller. So, for example, as well as things like bulk purchases set out in the bill, it may well be that we include something around reporting suspicious transaction to the Police or Trading Standards Authority, together with other requirements as well, which you wouldn't need to get to the criminal standard to be applied.
Yes. Can I just make clear that, though I'm going to move on from legislative change around this, subject to coming back to the point about the new offence, I'm not ignoring the difficult issue of cross-border importation. What you say in the witness statement is that is under the recommendations from the Clayman review about that are under active consideration, and work is continuing in the Home Office to assess or implement these recommendations.
It is.
Again, I'm not asking you to commit to a position now, but would you be able to keep us updated, perhaps by the end of November, as with Ms Elsmore,
Yes, we can.
on the course of that work?
Yes.
Who is responsible for investigating and prosecuting breaches of the existing legislation?
To the sales of knives?
Yes.
The police and local training standards authorities.
I think trading standards departments face quite substantial challenges, both in terms of their own resourcing, but also in dealing with online sales, which may not be clearly aligned to a particular local authority area.
That's correct.
And again, taking the example of the machete found in AR's bedroom, sold by Hunting and Knives, a UK company with an address, I think, in Wales, key company officers based in Spain, the delivery arranged by S.J. Henderson from Northern Ireland, and they then made use of two national companies, Whistle and Every, for transit and final mile delivery. It's quite difficult to see which local authority might deal with that chain of events.
It would be unclear. There will be a number of possible training standards who could have an interest in it. It very much depends on the complaints they might receive, depends on the intelligence which the police might get or the training standards might get about delivery and who's inclined to act upon it. There is a national training standards which acts as a coordinating authority if it cuts across more than one particular training standards body. But as going back to the review of online sales of knives, it's particularly difficult, I think, for training standards to enforce online sales of knives, which is why we're going back to the key role this new police team will play in this area.
And again, just picking a slightly different example, the 2,500 other bladed items that appear to have been delivered into the UK by Hunting and Knives. No one local authority is going to have an interest in all of them, quite clearly, and perhaps not even one single police force. Who do you think the correct law enforcement body to investigate that would be?
Again, it's very hard to say, depending on the circumstance of the case, where the complaint was made, where the major part of the incident was considered to have taken place. Talks between the respective law enforcement bodies about who would take the lead in that particular case.
If we can bring up the Clayman review now at HOM 30160. If we could go to page 14, please. And if we could have the paragraph legislation and sentencing enlarged. What Commander Clayman identified was the sales and marketing offences that can be used are not commonly identified in policing. It's an area where officers may not come across it in their day-to-day business. As such, the legislation is rarely used, and attempts to use it can encounter barriers at the prosecution stage, with those CPS prosecutors contacted never having dealt with a relevant offence. He then gives a specific example relating to the difficulties obtaining warrants in some circumstances. It's fair to say that these are not offences that are frequently prosecuted.
No, that's correct.
And you've told us about Commander Clayman recommended a national coordination function to help overcome that.
Yes.
Is that police unit that you've told us about?
It is, yes.
Can I come then to the new offence in the Crime and Policing Bill, as I promised I would? This introduces an amendment to the Criminal Justice Act 1988. It inserts a new offence of possession of an offensive weapon with intent to commit unlawful violence.
Yes.
And it also creates a power for the police to seize a weapon that they reasonably suspect of being intended for use in unlawful violence.
It does, yes.
Both of those would have application both in public but also in private places.
Yes.
On the assumption that Parliament does adopt this in something like its current form, would the intention be for there to be guidance issued by the Home Office in respect of this offence, as there is in respect of other offences under the 1988 Act?
There would be guidance, whether by the Home Office or jointly with the police and CPS and other bodies. There would be guidance.
Can you help us with what sort of things that might cover? I mean, for example, would simple possession by a teenager of a machete within a home address be regarded as sufficient for there to be a reasonable suspicion as to its intended use?
I think we've worked through a number of different scenarios to give advice to police and prosecutors about the kind of situations which might be considered as relevant factors when looking at whether an offence has been engaged or not.
There's all sorts of things that might be capable of being taken into account. You might have the characteristics of the weapon or the forensic history of the individual in possession of it.
There'll be a number of different factors that would be, that's why it's important that we clarify it in guidance, I think.
Thank you. I've spent some time dealing with the legislative framework and current potential reforms to it. Could I come on to some of the enforcement of the criminal law and the criminal offences in this area? In terms of police powers around weapons, stop and search is a highly significant one, various different statutory powers for it, but under that broad umbrella.
It would be seen as so, yes.
I think in the statement, page 70, paragraph 244, no need to bring it up, it's described as a key tactic for police to take dangerous weapons off the streets and protect communities from violence and other crime.
Yes.
But the statement goes on to make clear it's also a power that has to be exercised with a degree of caution and care, given the potential repercussions to the model of policing by consent.
Yes.
In effect, it's a power that can either be abused or be perceived to be abused.
Possibly so, yes.
Its effectiveness is likely to depend on how well that balance is struck to some degree.
That's right.
There is a relatively recent power introduced, the Serious Violence Reduction Order. Can you help us with how that works in the context of stop and search?
Yes. Serious violence reduction orders were introduced under the Police Courts and Sentencing Act of 2022. It provides that the police can, on conviction of somebody for a knife offence, for an over 18 for a knife offence, as a serious violence reduction order is also placed on that person as well. And this, in effect, means that that person can be stopped and searched at any time without the police having to have reasonable grounds to suspect. So it's different to a stop and search under the normal PACE rules.
They're effectively walking around in their own little Section 60 suspicionless bubble.
In effect, yes, yes.
Thank you. When somebody is found with a weapon, the decision on whether or not they should be charged is one for the police, or probably more likely, because they're either way offences, for the CPS.
That's correct, yes.
Can we have HOM 30176, please? Not a Home Office document, although it's the Home Office have produced it. CPS and National Police Chiefs Council guidelines on the cautioning and charging of knife offences, knife crime offences. It's dated 2022. Do you know whether this is a significant change from any earlier guidance, or is this continuity?
It replaces the 2015 APO guidance. The 2015 APO guidance was quite a significant step at the time in terms of charging of 16 and 17-year-olds rather than leaving it to out-of-court disposals. The 2022 guidelines you see here were evolved after a consultation with police forces, which was delayed during the pandemic, which is why it didn't come out until 2022. But it made it clearer how to treat 16 and 17-year-olds, but also those under 16 as well.
Thank you. Can we look to page 3? This page deals with adults and also with 16 and 17-year-olds, as you say. Expectation is that those aged 18 and over will be charged for all knife-related offences. For 16 and 17-year-olds, the starting point for children and young people aged 16 or 17 for simple possession should be to charge,
yes,
unless there are exceptional circumstances, in which case potentially a youth conditional caution.
Yes.
And where there's any history of offences of violence, previous offending knife or violent or weapon offence, or it's an offence more serious than simple possession, they should be charged.
Yes.
And then the next page, please. This deals with children and young persons under 16. I'm sorry, one page back, please, page 4. And if we could have the text at the top enlarged, please. Starting point for a child aged 16 for simple possession who has not previously been involved in any violent offending or offences including knives or weapons should be a youth conditional caution.
That's correct, yes.
But then bottom paragraph, where the suspect has any history of offences of violence, has been previously dealt with for a knife/weapon offence, or the offence under investigation is an offence other than simple possession, then they should be charged.
Yes.
I think there is also work underway in conjunction with this charging guidance to ensure that whenever somebody under 18 is found in possession of a knife, whether they are charged or not, there should be a referral to a youth offending team.
That's correct, yes.
Could we have YJB 30112 up, please? This is a material from the Youth Justice Board from August this year. Could we have page 15 up, please? It is the aim of those mandatory referrals to the youth offending team wherever anyone is found in possession with a knife. Is that an example of the sort of individualised decisions on outcomes that the YJB supports here?
It is. It's ensuring that the individual young offender gets an offender plan that deals with a particular reason for their offending.
You described them as a young offender, but in fact it would cover even if they weren't charged or...
Yes, well, there'd be an admission, yes.
Thank you. That can come down, please. Could Could I ask about knife crime prevention orders? These were introduced by Part 2 of the Offensive Weapons Act 2019,
They were, yes.
and they were a form of civil order, so they could be imposed either on conviction or on a freestanding application by the police.
They could be, yes.
They could impose both positive requirements and negative prohibitions.
Yes,
And breach, I think, was a criminal offence.
it was, yes.
The Act required that before the relevant provisions were commenced nationwide, they had to be piloted,
Yes,
and a report on the pilot laid before Parliament. And that pilot duly took place in the Metropolitan Police area between, I think, July 2021 to March 2023.
that's correct, yes.
There hasn't been a report laid before Parliament. Can you help us with why not?
There wasn't a report laid before Parliament on the basis that the pilot wasn't going to be rolled out nationally. The view was taken that if the pilot wasn't going to be rolled out nationally, a report to Parliament wasn't necessary because that's the way that the provision was read. As part of the provisions put into the Offensive Weapons Bill at the time as the measure was going through Parliament.
And if we could have HOM 4085 up, please. This is part of the evaluation of this pilot. And if we could have page 3 up, please. Summarising it as best I can, despite some difficulties with the data and the ability to analyse that fully, the conclusion was, and we see this in the second paragraph, no significant differences across treatment and control groups, treatment groups those that received KCPOs, in terms of probabilities of reoffending, probabilities of being charged with an offence, and the number of offences committed. People in the treatment group and control group also appeared to reoffend with similar delays.
Yes,
In other words, they didn't work.
exactly.
There was a study, I think, by University College London, which was a more sort of qualitative debriefing study of those involved.
Yeah.
We don't need to bring it up, but so it's at HOM 4087.
Thank you.
Again, is it a fair summary to say that police and CPS respondents had concerns that were more focused on resourcing and issues over implementation?
Yes.
Youth offending service staff had more principled objections.
They had more fundamental concerns, yes. Yeah.
What were the reasons then for not rolling this out? We've seen some of the qualitative stuff summarised there. You also had the concerns over resourcing and implementation. You have the youth offending service with principled objections. Talk us through the decision to say, no, post-pilot, we're not going to roll these out nationally.
I think looking at the two evaluation reports, one of you said highlights that they seem to have no impact on reoffending between the two different groups in the randomised controlled trial. Also, when talking to the various kind of agencies involved in the KCPOs, there were concerns, particularly by policing, about resourcing and whether the right people to actually identify the right conditions to be placed in a KCPO. But there were more fundamental concerns by youth offending teams, by youth justice services in terms of actually, are we duplicating what is already possible under a youth referral order or a offending plan from the youth offending team? Or is there also what they described as a moral dilemma, I think, in the report, where they spoke about whether they would be criminalising particularly the young person who may be subjected to a KCPO because a non-compliance with the order would be regarded as a potential criminal offence, and which would mean they'll go back into the court and be prosecuted for not complying with the KCPO. So I think that was particularly a stumbling block for buy-in from youth justice services.
I've been asked to explore whether a lack of resourcing to make these work properly was behind the reason either that they weren't rolled out or that they didn't work. Would that be a fair comment to make, or is that rather too simplistic?
I don't know. I think it's a bit more complex than that. I think you've got to know some of the context about the introduction of the KCPOs and Defence of Weapons Bill. The KCPOs were an idea developed by the Metropolitan Police at the time when we saw a very significant increase in knife crime. It doubled within 3 or 4 years. In 2018, during the passage of the Defence of Weapons Bill, Metropolitan Police submitted to ministers a proposal for KCPOs supported by the National Police Chiefs Council. On the basis of that, ministers agreed to put the proposal for KCPOs into the bill, unusually without consultation, which is an unusual step to take, which is a complex measure. In retrospect, it would have benefited from a consultation so that the kind of issues which are then exposed by the pilot would have been anticipated in the design of the legislation going into the Defence of Weapons Bill, and therefore could have been piloted and so forth. I think as the bill was going through, the addition of offences connected to the non-compliance particularly made it problematic for youth justice services. So I think it's much that than any lack of resources was the issue here.
And can we just think about how this might have been applied in AR's case? He was convicted of a knife offence possession in February 2020. That, I think, was prior even to the pilot starting by over a year. So he couldn't have received one on conviction.
No.
And then when he was found with a knife in March 2022, even if the provisions had been enforced nationally, I think he wouldn't have been eligible for a KCPO on application by the police, because the trigger for that was there had to be 2 instances of possession within 2 years, and so he would have fallen just outside that.
Possibly, but he would have been able to be subject to youth conditional caution, subject to the police taking that route.
And so you would look to something like a youth conditional caution, or indeed other tools you've mentioned, youth rehabilitation order, to try to impose positive or negative conditions on somebody with a persistent challenge of possessing knives, rather than focusing on the KCPO as a particular tool to achieve that.
I think so, because if the person's charged, goes to court, convicted, then there's a youth referral order or youth rehabilitation order or whatever, or detention order. And if they're not subject to youth conditional caution, which again, similarly, in an offending plan, you'd have a set of kind of punitive or more punitive as well as positive measures as part of the offending plan they're subject to.
So in effect, even though somebody isn't taken all the way through the criminal justice system with a charge and a conviction, there are still measures available to the police, things like youth conditional cautions, to try to address the underlying behaviour.
There is, and there's going to be, based on making referrals mandatory to youth offending teams if a child is caught in possession of a knife, there'll be government guidance coming out very shortly about this as well, to reaffirm this is the approach to take.
Thank you. There's a very small number of further topics I just want to canvass with you, Mr. Hunt. The first is, could you tell us about the knife-enabled robbery task force, which I think the Home Office has supported for a number of police forces? It's page 72 and paragraph 253 of the witness statement. Yes.
The knife-enabled robbery task force was created as the largest single category within knife crime is where a knife has been used to enable a robbery to take place. I think it's about 43% of all knife crime is connected to robbery in some way. And so that was increasing particularly rapidly in the year to June 2024. I think it's gone up by about 11% in 1 year, and it's driving the overall increase in knife crime. So as a result of that, we put together a task force of those 7 areas in the country, 7 police force areas in the country with the highest levels of robbery-related knife crime. and was the idea that they would work together to collectively drive down and tackle robbery more effectively, particularly knife and nail robbery more effectively over that 12-month period of time.
And I think the conclusion appears to be that that was a successful initiative.
So far, yes.
What's said in the statement is that it involved enhanced enforcement, intelligence-led interventions and coordinated support. Could you expand on that a little as to what exactly?
I'll try and explain it the best I can. It's looking at the data they have about where those robberies are taking place, the times they're taking place, and any other characteristics around those particular robberies. So, for example, smartphones clearly a big item which is stolen. And an example would be, for example, focusing on after school time. Is children leaving school after, in the evenings, late afternoons, the routes they go home, the bus routes they're taken, and whether or not you can focus on those routes by having more visible police presence, police in uniforms and so forth, as a deterrent to those children become victims of knife and nail robbery.
Thank you. Paragraphs 252 to 256, we talk about a number of non-statutory programmes and projects to help address the risk of knife crime. Things like violence reduction units, Knife Crime Coalition and the Young Futures programme. Are those the sorts of initiatives that typically at local level sit within the serious violence duty?
The serious violence duty will support them. The violence reduction units predated the serious violence duty and they've been in place since 2019. Again, in 20 police force areas around the country, including Lancashire and Merseyside, with the highest levels of knife crime compared to other areas of the country.
Yes, we've heard about the Lancashire's Violence Reduction Network. Is that an example of one of those?
It's an example of a violence reduction unit. They're very much evolved and adapted to reflect the local geography and local factors at play, but that is a violence reduction unit.
There was also, I think, a knife surrender scheme in the summer of 2025.
Yes.
Is that regarded as having been a success?
There was an extended surrender scheme, as you say, in summer 2025. Involved the location of new surrender bins, a van adapted to be able to take knives and swords safely and deliver them to a local police station, being surrendered in. The results have yet to be published to Parliament, but the feedback we've had is that it was received very successfully by the communities in which it was based.
Without wanting to pour cold water on that perception, I think the Youth Justice Board, in the analysis that we looked at earlier, YJB 30112, suggests that knife surrender schemes have a very low impact on reducing knife crime. Are you familiar with those?
I'm familiar with those words from the Youth Justice Board. I think it's arguable. I think you've also got to think about community confidence as well. And the feedback we got, not simply ourselves, the Home Office, but the police and others involved in the scheme, were very positive in terms of the impacts that was having locally as well, being seen to visibly take knives off the street.
So community confidence, something that needs to be borne in mind. Is it also fair to say that this is a field where there can sometimes be an awful lot of ideas, but it is not always clear which ones, in fact, work?
I think knife crime is a very complex issue which takes more than one solution to be able to respond to it.
What does the Home Office do in terms of measuring impact and ensuring that the projects it picks and supports and invests time and money in are those that are going to have the greatest impact on crime numbers?
We've put a lot of effort into that, particularly from the serious violence strategy in 2018 onwards. We've been as full as we can in setting out the evidence base supporting the programs that we're putting into place. One of which is the Youth Endowment Fund in 2019. And one of the biggest reasons for having that Youth Endowment Fund is that it can test and evaluate different approaches towards knife crime, whether it be stop and search, whether it be particular schemes, targeted intervention, what's the most effective way of dealing with offending behaviour.
And does the Home Office then coordinate to ensure that where there are lessons identified, effective interventions identified, that different police forces, different local authorities, different regions know what others have done that works?
We do. I mean, the Home Office regularly convenes meetings, putting together all the different violence reduction units, police forces, to share findings, the best evidence in this area, to try and make sure that there's greater awareness about what works, what doesn't.
And I think the overall aim is a 50% reduction in knife crime. Am I right, by 2029?
No, it would be by 2034,
2034.
within 10 years of the last election, yeah.
How confident are you that that is a target that can and will be met?
It's a very tough target to meet. We're monitoring it extremely closely, as you can imagine, and we're looking to put forward a number of different interventions, whether the knife-enabled robbery task force to drive down the biggest area of knife crime is robbery, to try and reduce the figures, whether by taking knives off the streets, whether by putting more money into intervention, prevention programs. It's a whole kind of suite of different measures that are being put in place, already in place, to try and achieve that figure.
The last thing I want to ask you about, Mr. Hunt, is the Safer Knife Replacement Scheme. It's a post-Southport initiative aimed at reducing the number of sharp-pointed kitchen knives and replacing them with round-tipped knives, particularly for homes where there is a risk. At paragraph 262, page 75, it said that the Home Office is doing work with retailers and manufacturers about how best to take that forward.
Yes.
Can you expand on that at all?
Yes. Rounded tipped knives, kitchen knives, is something that the previous Home Secretary was supportive of us looking at to explore whether a scope to encourage a greater take-up by consumers of rounded tipped kitchen knives as a way to replace sharp-pointed knives, particularly in the kitchen and the domestic circumstances. We know that kitchen knives in particular are used in domestic homicides, and maybe as a way of reducing that or the severity of the injuries caused by those knives, to look at the idea of encouraging the greater take-up of rounded tipped kitchen knives. And we put together a round table with manufacturers and retailers to explore that, and we're working with them now to try and put together a set of incentives that might be encouraged to greater take-up.
We've heard that the police in this case, on a number of occasions, advised AR's parents to lock knives away. Would this scheme be the sort of thing that could be offered to families in that position?
Are you talking about this Kent scheme here, or more generally?
Well, I think the idea of offering families where there is a risk of kitchen knives being used in violence, round-tipped knives, would that be the sort of intervention that could be offered rather than offering advice to lock knives away? Say, actually, here is a constructive proposal to reduce the risk.
I understand that's what they're doing in Kent, actually. It is offering to replace sharp-pointed knives in the kitchen with rounded-tipped knives. Kent's a very positive violence reduction unit. They're very positive about the impact it's having, so we're looking at it to see what evidence there is and whether it might be put onto a bigger scale, but we're looking at it very closely.
Thank you. Is there anything else you want to add, Mr. Hunt, to what I've asked you about?
No, it's fine, thank you.
I don't know if there's any questions from my left. No. So I wonder a short break for our stenographer, and there is a summary of remaining CTP evidence before we finish for the day.
Just before we let Mr. Hunt go, a few questions from me.
I'm sorry, sir.
First of all, you've indicated that the Home Office thus far, I don't think, has investigated, tried to get some data on the lawful purposes for possessing machetes. That's surely not an impossible task, is it? To find some reliable evidence as to what the lawful purposes are.
In terms of simple figures, I think we've been trying to get data from retailers and others about the sale of knives, including machetes. I think it's clear from previous consultations and responses we got the reasons why people think that they have a legitimate reason to have machetes. But in terms of the numbers in circulation, we don't have that.
Yes, I mean, we've heard some evidence, as I'm sure you're all aware, during the course of the hearings so far, of what are said to be justifications for the possession of machetes. And of course, one can see that in some particular instances, those are no doubt viable. Mm-hmm. But certainly at this stage of the inquiry, and based on what I've heard, that there doesn't seem to be a particularly strong evidence base for suggesting that machetes need to be widely available with almost no restriction, mm-hmm. given the extent to which they may feature in crime. I mean, is there anything you would want to say about that?
I don't think I want to add anything more than that. I think there's a fair observation.
All right. There was a 2023 consultation and a comprehensive review, I think 12 months ago. Mm-hmm. I think I've already asked another witness, I can't remember which, for a copy of what arose out of the consultation. But can you make sure that I get that, please?
Of course, yes.
Together with anything that's been provided by way of the comprehensive review.
Yes.
Thank you. Mr. Goss took you to the split responsibility between the police and local trading standards over prosecuting that which is bought via the internet. And although I don't think we've been provided with figures, certainly the tenor of your evidence has been that prosecutions are a rarity.
They're very low. They're not a rarity, but very low.
Right. Given that trading standards they are obviously focused on a particular area, and purchases over the internet cross all boundaries, has thought been given to setting up an equivalent body, but one which focuses on internet sales rather than a geographical area?
We hope and intend that the new police coordinating team will cover a lot of that. They will also include training standards as part of the kind of spoke model they're developing as well. Therefore, it will be a better kind of understanding and use of intelligence about who would be best placed to direct an investigation towards doing, if the team themselves don't do the investigation itself.
Yes. I mean, I'm going to have to obviously look very carefully at what this national coordination function is going to amount to, but it's not going to be a prosecuting authority, is it?
No, it's going to be investigating. It's a police investigating unit.
And so that's not going to address the difficulty over different local trading standards authorities not taking responsibility for prosecuting, as it were, the generality of knives that are sold across the internet. And are you confident that a national coordinating function is going to be able to resolve that problem, Mr. Hunt?
I think there's a lot of goodwill there. I think there's a strong relationship between that developing team and the National Trading Standards coordinating body. And I think that there'll be enough there to be able to work through how to improve, particularly online prosecutions. Who's responsible for doing that?
When are they due to produce something in terms of literature that will give a firm idea as to actually how much assistance they're going to be able to provide in this vexed area.
I mean, I don't really want to speak on their behalf but it's being developed at the moment. The team's just being set up at the moment, so I wouldn't want to commit them to a particular deadline, but it is being set up now.
So, by the sounds of it, unlikely to assist me in phase 1, but there may be something by the time we
Certainly,
get to
but I hope by
phase 2.
phase 2.
I've done a word search, and I can't find in Ms. Elmsmore's statement, although I might have missed it, what you have relied on in relation to youth conditional cautions and youth rehabilitation orders and the place, or rather the part, that they can play in relation to this. Can you do a short note?
Of course.
It doesn't need to be a doctoral thesis, but a couple of sides of A4, as to how you see them fitting into this landscape.
Yeah.
Mr. Hunt, thank you very much.
Thank you.
Free to go.
Thank you.
Short break?
Yes, I think
How long?
perhaps just 5 minutes.
Yes, I'll sit again.
Perhaps 10 minutes if we could. We have a very short amount of reading left to do.
All right, 10-2.
Thank you, sir.
Yes, Mr. Boyle.
So we've reached the conclusion of the live evidence from counter-terrorism policing, and in relation to AR's contact with Prevent, there are a small number of further statements to summarise for the record. Many of the matters raised in the evidence of these witnesses have been canvassed with others, particularly DTS Ken Wright and DAC Evans as corporate witnesses for counter-terrorism policing. Of course, the fact that these witnesses have not been called to give live evidence is not to be taken as an indication by the inquiry that their evidence is accepted entirely as written. What to make of all the evidence, including the written evidence, remains a matter for you in due course. So the first statement is that of Temporary Chief Inspector James Neal, which is CTP NW 166, dated the 13th of August of this year. Temporary Chief Inspector Neal, now in local policing in Lancashire Constabulary, was a sergeant in the CTP NW Prevent team in December 2019. He was the supervisor who authorised the closure of AR's first Prevent referral on the 31st of January 2020. He sets out his background and experience, including that he joins the Prevent team as a sergeant from February 2017 to July 2020, albeit that this was not continuous. In 2017 to 2018, he spent 8 months in another CTP team. He describes the structure of Prevent and Channel, including Dovetail. He then sets out the team he supervised, 8 CTCOs covering Lancashire and Cumbria, with 2 supervisors, himself and PS McIntyre, and an inspector and a chief inspector equivalent above him. His focus was on Cumbria and North Lancashire. He sets out the day-to-day running of the office and the extent to which he, as a supervisor, was involved in the CTCO caseload. He details his training and experience, including that he moved from his role before completing the new National Prevent Foundation course, as they were prioritising CTCOs to complete it. He says that there was, quote, a lot of CPD/training more generally, close quote, and he recalls training throughout the year for Prevent officers and staff so that people were up to date with current issues relating to Prevent functions. Turning to the first referral, he was aware of it when it first came in, as he was copied into emails, though it was within the geographical area that PS McIntyre would more usually focus on. He was the supervisor who transferred the case to PC Thompson on the 17th of December 2019. He was also the supervisor who authorised the case for closure. He recalls speaking with PC Thompson and PC Lawrence, the CTCOs who had visited AR at his home. He recalls that, open quotes, both officers held the strong opinion that AR was not suitable for referral to Channel, close quotes. He sets out his rationale for closing the case, including the assessment of the FIMU of no CT/DE relevance, which he describes as a, and I quote, persuasive factor. His view was that AR's violence was criminal violence, to quote, rather than terrorist in nature. He did not think that AR was presenting as having an obsession with school massacres. He then sets out some broader considerations about the interactions between Prevent and the FIMU, about the Vulnerability Support Hub, about the role of the 2019 joint letter, and various other factors within his assessment of the case. His overall view was that having reflected on the case, open quotes, I do not think, in the absence of additional or new information, that I would have reached a different conclusion, close quotes, about continuing AR's first referral within Prevent. So the next witness is Officer A, who's provided two statements, CTP NW 179 of the 25th of August and CTP NW 417 of the 25th of September of this year. Officer A is a temporary detective sergeant in the Lancashire FIMU within CTP Northwest. He was the officer who received the first Prevent referral on the 5th of December 2019 and asked the Acorn School to fill out the Prevent referral form. He deals with that in his second statement. He also conducted the FIMU assessment of AR's second referral to Prevent, received on the 1st of February 2021, which he deals with in his first statement. Also in his first statement, he sets out his experience in training and a summary of the role and capabilities of the FIMU, including his recollection of how it interacted with Prevent. Turning briefly to his second statement, as that deals with matters coming first in time, he sets out that he had not previously remembered being involved in the first referral on the 5th of December 2019. He describes his role as a, open quotes, minor administrative communication, close quotes, and notes that it took place prior to Officer B's assessment of the first referral. He makes clear that based on his review of the available documents, he does not believe that the Internet search history, LCC 001401, was provided to CTP Northwest by the Acorn School. He says that it was not unusual to receive referrals into the concern inbox that did not make clear the basis of the referral. In those cases where the case did not appear to be urgent, it was routine to ask the referrer to complete the Prevent referral form. This would involve some review of the material, but it was not the same as conducting a substantive FIMU assessment of that material. He sets out the notes he made on the referral, including describing what was sent as a, open quotes, large dump of data from the school, close quotes. When the referral was remade the following day, it was picked up by Officer B. Officer A had no further involvement. Officer A then sets out his reasons based on analysis of the documents why he does not consider that the Internet search history was sent to CTP Northwest. He also sets out the limitations that would have existed in relation to analysing that material within the FIMU. You've heard about those from Officer B. Returning to Officer A's first statement, after setting out his experience and training, he then describes the receipt of the second referral from the Acorns on the 1st of February 2021, which related, as we've heard, to screenshots from AR's Instagram account concerning Colonel Gaddafi. He describes carrying out the FIMU assessment of the referral and then sharing the outcome with the Lancashire Prevent team. He has no recollection of being contacted by the Prevent team about the case. He does not recall the steps that he undertook as part of the assessment, though comments that from the papers it's clear that he took account of the first Prevent referral and its outcome, took steps to identify social media accounts for AR, though he didn't locate AR's Instagram account, and checked a number of police databases. His rationale for determining that the second referral was not CTP relevant was as follows, and I quote, "As such, I do not believe that this new intelligence is worthy of a new prevent referral, as I do not assess it would meet the thresholds for adoption at Channel, and the content does not suggest he holds any extremist ideology, but rather an opposing opinion on Gaddafi's Libyan regime, questioning the US and EU motivation for removing him." He says that he knew it was not the role of the FIMU officer to make prevent assessments or to tell prevent what they should or shouldn't do with a case. Open quotes, "I don't have a sufficient understanding of the prevent thresholds and role to make such an assessment," close quotes. He accepts that his assessment could have been worded differently, but says that, open quotes, "I do not consider that assessors should be restricted in setting out their views," close quotes. It was not, however, intended as a guide or instruction to the prevent team. He concludes his statement with some reflections on changes to practice since 2021 and on potential further improvements. So next is DC Timothy Aspinall. His statement is CTP NW 173, dated the 18th of August. Mr. Aspinall was a detective constable in the FIMU between September 2018 and December 2022 when he retired from the police. He sets out the background and role of the FIMU as well as his training and experience. Mr. Aspinall was the FIMU assessor for the third prevent referral in respect of AR. He describes receiving the referral from the Acorn School on the 22nd of April 2021 and sets out a summary of its concerns. He describes the searches he undertook as part of the FIMU checks. He had the records of the first and second prevent referrals available to him, as well as checking police systems, which revealed AR's conviction and the October 2019 incident on Lancashire systems. He also carried out open source checks, which were no trace for AR. His conclusion was that the third prevent referral was not CTP relevant, and he assigned it the corresponding RADO outcome, RADO 6. His rationale was, and I quote, "As per the previous PCM, Colonel Gaddafi, I do not feel this new reporting holds any CTDE vulnerability and only highlights and interest in world news and current affairs, which is a trait of ASD. Subjects' educational needs are being met at Acorn, and it's clear that the teachers are aware of reporting any future concerns." Close quotes. He then passed the case to the Lancashire Prevent team. He does not recall having any discussion with them, and the case was not referred back to the FIMU. In the remainder of his statement, he addresses the comment he made about, open quote, knee-jerk referrals, close quotes, accepting that his language could have been better chosen, but explaining that he meant to, open quotes, highlight internally that sometimes referrals can be made by a student who continues to be challenging that, whilst in good faith, does not increase the risk in terms of counterterrorism vulnerabilities, close quotes. He sets out his understanding of autism and the impact that had on his decision-making, as well as the social media and open source checks he carried out. He makes clear that when considering CT/DE vulnerability, open quotes, the idea of unclear, mixed or unstable ideology was not at the forefront of my mind, and none of the concerns raised in the third prevent referral were related to school massacres, close quotes. Having been asked to reflect on his involvement and having considered the impact of hindsight, he maintains the view that the assessment he made from a FIMU perspective was the right thing for him to have done based on what was known at the time, on the basis that the concerns reported were already being addressed by a multi-agency response. So that concludes the CTP evidence. We break now until Monday due to other engagements at the Town Hall. On Monday, we commence evidence in relation to mental health and hear from practitioners from all the Hay Children's NHS Foundation Trusts. So we're timetabled to sit from 10:30 rather than 11 on Monday.
Thank you very much indeed, Mr. Boyle. Then Monday at 10:30.